Hello, welcome to Vidula Niti. Today's topic is about a citizenship. Article 5 to 11. Introduction of a citizenship. The Constitution of India provides a single citizenship for the whole of India. Every person who was at the commencement of the Constitution domiciled in the territory of India. Citizenship is the status of a person recognized under the law as being a legal membership of a sovereign state or belonging to the nation. A citizen is a given a state is a person who enjoys full membership of the political community or a state. Our population of a state is divided into two classes. They are citizen and aliens. Citizens are different from aliens or mere resident who do not have all the rights which go to make a full membership of a state. Thus, in India, aliens do not enjoy all the fundamental rights secured to the citizens. Again, citizens alone have a right to hold certain high offices. Thus, citizens of India have the following rights under the Constitution, which aliens shall not have. First one is some of the fundamental rights belonging to citizens alone, such as Article 15, 16, 19. Only citizens are eligible for certain offices, such as those of the President, Vice President, Judge of a Supreme Court or a High Court, General Attorney, Advocate General, etc. Nature of a citizenship. Citizenship means membership of a state. This principle, all persons born on the state's territory becomes its citizen. Thus, citizen is born, not made. They confer citizenship on those born on their nations anyway in the world. That is, if a parent is a citizen of a state A, the child also becomes its citizen. Here again, citizenship arises by parentage, that is, by birth. That is why it is sometimes said a citizen is born, not made. Rules of the citizenship. These are divided into two: Article 5 to 11 and Citizenship Act 1955. Article 5 to 11. Who has declaration of the citizenship on 26th January 1950. It deals with the person who became citizen on the day of the commencement of the Constitution. This part doesn't say how to acquire Indian citizenship in future. Citizenship Act 1955. It deals with the acquisition and termination of the citizens since it was not mentioned in the original Constitution. Constitution empowered Parliament to enact the law to provide for such matters, any other matters relating to the citizenship. Article 5. Citizenship at the commencement of the Constitution. Article 5 lays down two conditions. First is, at the commencement of the Constitution, a person must have his domicile in the territory of India. Second is, such a person must fulfill any one of the three conditions laid down in the article, namely, he must be born in Indian territory, or either his parents must have been born in the territory of India, or he must have been ordinary resident in the territory of India not less than 5 years, immediately preceding the commencement of the Constitution. A domicile means an ancient place, means a permanent home. Residence means a temporary being you'll be staying. Let me give an example of this. Article 5. A is a daughter of Iranian nation. She was born in 1921 in India. Her mother belongs to Madras. A has a positive intention of making India her permanent home. She never left India since her birth. Her father died in 1926. Is A is our Indian citizen? Yes. she acquires a Indian citizen. She is born in India. She has her domicile in India. So, at the commencement of the Constitution, she processes the qualification of the citizenship under Article 5. The nationality of her parents is immaterial in such a case. Domicile, there are two types, by origin or by a choice. Domicile by origin. A domicile by origin may be understood as a domicile which is received by him at his birth. To a ligament child, the domicile of a father is assigned, and to a illigament child, the domicile of a mother is assigned. Let me give an example by a case study. Pradeep Jain versus Union of India. The Supreme Court has held Article 5 recognize only one domicile, that is, domicile of India. It does not recognize state domicile. If a person moves from one state to another state to settle permanently, he has one citizenship, that is, citizenship of India. Here, we will be having only one citizen of India. If we move to another state, there is no making of a citizenship. We can move anytime. Domicile by a choice. Before obtaining the full age, an infant is not capable of acquiring his own act any independent domicile of choice. A domicile of a married woman is a domicile of her husband. Michael versus State of Bombay. A person is born in Goa and came to Bombay in his boyhood, educated and resided in there, and continued his father's business in Bombay. He was held as an Indian citizen by domicile by a choice. Means any person have their own choices to pick the residentialship. Here, a person Michael had been born in Goa, but he came to Bombay in a childhood and educated there, and he continued his father's business in Bombay. It was his choice. There was no any force or any dominant person. Next is Article 6. Rights of citizenship of a certain person who have migrated to India from Pakistan. Article 6 refers a person who have migrated from Pakistan to India have been classified into two categories for the purpose of citizenship. That is, those who came to India before 19th July 1948 and those who came to India on or after 19th July 1948. Article 6 provides that the person who has migrated to India from Pakistan shall be deemed to be a citizen of India at commencement of Constitution, that is on 20th January 1950. If he or either of his parents or any of his grandparents were born in India as defined in the Government of India Act 1935. In case such a person has migrated after July 1948 and he has been registered as a citizen of India by an officer appointed in that behalf by the government of the domain of India on the application made by him. Therefore, to such an officer before the commencement of the Constitution provided that no person shall be so registered unless he has been registered in resident of the India for at least 6 months immediately preceding the date of his application. Next is Article 7. Rights of citizenship of certain migrants to Pakistan. Under Article 7, a citizen of a domicile or a citizen by migration of India from Pakistan ceases discontinues to be a citizen if he has migrated to Pakistan after 1st March 1947. However, This rule is subjected to an exception if he fulfills the conditions under Article 6. Now let me give an example. X and his wife Y was having a child called Z, were all the citizens of India. In March 1948, X and his child Z left for Pakistan and stayed there for over 6 months, and there was no explanation for such stay. X continued to live in India. Now, Y and Z considered to be a citizen of India makes it clear that there and to be a migration without a change of domicile. Here, Y's domicile and her child Z domicile continue to be an India because ZX is an Indian. Still, there is a migration and loss of Indian citizenship. Migration means moving from one country to another, not being for a short visit. Next is Article 8. Citizens of certain persons of Indian origin residing outside India. Any parent or a person or their grandparents born in undivided India but residing outside India shall become an Indian citizen of India by diplomatic representative of India in the country of reside. This article deals with the right of a people of Indian origin residing outside the India for the purpose of employment, marriage and education. Next is Article 9. Persons voluntarily acquiring citizenship for a foreign state not to be a citizen. Here, any person voluntarily acquired the citizenship of a foreign state will be no longer a citizen of India because India doesn't allow dual citizenship. India will allow only single citizenship. Article 10. Continuance of the rights of the citizenship. It says that every person who is or is deemed to be a citizen of India under any foregoing provisions in the part of the shall subject to the provision of any law that may be made by Parliament continues to be such citizen. Article 11. Parliament to regulate the right of the citizen. It empowers Parliament to make any provision with respect to the acquisition and termination of citizenship and all matters relating to it. The Parliament has a right to make any provisions concerning the acquisition and termination of citizenship and any other matter relating to the citizenship. Next is acquisition of Indian citizenship. Indian citizenship can be acquired by birth, descent, resignation, and naturalization. The conditions are providing for the acquisition of Indian citizenship as per the provision of the Citizenship Act 1955 are given below. By birth, Section 3. A person born in India on or after 26th January 1950 but before 1st July 1987 is a citizen of India by birth, irrespective of the nationality of his parents. Next is the person born in India on or after 1st July 1987 but before 3rd December 2004 is considered to be a citizen of India by birth if either of his parents is a citizen of India at the time of his birth. A person born in India on or after December 3rd, 2004 is considered citizen of India by birth if both the parents are citizen of India or one of the parents is a citizen of India and the other is not illegitimate migrant at the time of his birth. By descent. A person born outside India on or after 26th January 1950 but before 10th December 1992 is a citizen of India by descent. If his father was a citizen of India by birth at the time of his birth, in case the father was a citizen of India by descent only, that person shall not be a citizen of India unless his birth is registered in an Indian consulate within 1 year from the date of his birth or with the permission of the central government after the expiry of the said period. A person born outside India on or after 10 December 1992 but before 3rd December 2004 is considered as a citizen of India if either of his parents are citizen of India by birth at the time of his birth. In the case of either the parents was a citizen of India by descent, then the person shall not be a citizen of India unless his birth is registered at the Indian consulate within 1 year from the date of the birth or within the permission of the central government after the expiry of the period. A person born outside India on or after 3rd December 2004 shall not be citizen of India unless the parents declare that the minor does not hold a passport of any other country and his birth is registered at the Indian consulate within 1 year of the date of the birth or with the permission of the central government after the expiry of the said period. Next is registration. Indian citizenship by the registration can be acquired. A person of Indian origin who are ordinarily resident in India for 7 years before making application under section 5 of 1 of A throughout a period of 11 months immediately before making the application and for the 6 years in the aggregate in the 8 years preceding the 11th month, application shall be made in Form 1. Person of India origin who are ordinary resident in any country or a place of outside undivided India under section 151 of B. A person of full age and a capacity who are a citizen of a country specified in the first schedule of the Citizenship Act 1955. Any minor child can be registered as a citizen of India under 5 of 4 section if the central government is satisfied that there are special circumstances justifying such registration. Next is by naturalization. Citizenship of India by naturalization can be acquired by foreigners, not illegitimate migrant who is ordinary resident of India for 11 years throughout the period of 11 months immediately preceding the date of the application and the 11 years of the aggregate in the 14 years preceding the 11th month and the other qualification are specified the third schedule to the Act. Application shall be made in Form 12. When our application is made by the prescribed manner by any person of a full age and the capacity who is not a citizen of a specified in the first schedule, a person to whom certificate of the naturalization is granted shall, on taking a oath of allegiance in the form of specified in the second schedule, to be a citizen of India by naturalization as a form of a date on which a certificate is granted. Can company or a corporation be a citizen? No. Citizenship in India can only be held by natural persons and excludes artificial persons such as companies and corporations. Though a company is a legal person, it is not a citizen under the constitutional law of India or the Citizenship Act 1955. The reason as to why the company cannot be treated as a citizen is that citizenship is available to individuals or a natural person only, not for a juristic person. Let me tell an example for a case, that is State Trading Corporation of India versus Commercial Tax Officer. Fact of the case. In this case, the State trading corporation was sought to be taxed in respect of the sales effected by them in the course of their business operation. The corporation contended that it is a transaction related to the interstate sales and was therefore exempted from the taxation by Article 286 1 of A. The illegal tax was therefore infringed in the fundamental rights under Article 19(1) of G to carry on the trade or a business. Judgment. The Supreme Court held that the company or a corporation is not a citizen of India and cannot. Therefore, claims such as fundamental rights have been conferred under citizens. That citizenship conferred on a citizen by a Part 2 of the Constitution. The court said citizenship concerned only with the natural persons and not juristic persons. Further, the court said the state trading corporation was not a citizen and therefore could not claim the rights under Article 19(1) of G. Thank you. Please like and subscribe. Next video will be on Article 12 State.